The doctrine of attorney-client privilege. Have you ever been on the wrong side of the law and wondering whether you should spill everything to your lawyer? Have you ever found yourself wondering whether it is safe to tell your lawyer the whole truth and nothing but the truth? You are not alone on this. And this is where the doctrine of attorney-client privilege comes to play. So today, we will look at this doctrine, what it means, the statutory provision for it, how it is practiced, some examples of attorney-client privilege, and the remedy if breached. Hi, welcome to Legal Tips with Ared. I am Ared, and it is my pleasure to welcome you to Legal Tips with Ared today. Is this your first time with me? I am glad to host you. Please subscribe so that we can continue seeing each other. You've been here before but yet to subscribe. Can you please do that today? And of course, turn on that notification bell so that we can always be on this cruise together. Knowledge is power. And that's what Legal Tips with Ared, your reliable plug for everything legal stands for. Remember, prevention is better than cure. And a simple tip can well be that prevention. What is the doctrine of attorney-client privilege? This is the legal protection that prohibits attorneys, lawyers, from disclosing confidential communications between themselves and their clients. An attorney-client relationship is like a doctor-patient relationship. If you are economical with the truth, the doctor will not know what to treat. If you do not tell your lawyer the truth, he will not know how to defend you properly, and lawyers hate being disgraced in court because of something you should have told them but did not. And as such, the legal system encourages the client to trust his lawyer by protecting the client with the right to refuse to disclose and also prevent his lawyer from disclosing the confidential communications between them. Attorney-client privilege is a fundamental aspect of the legal profession. And as such, your lawyer is under a very strong obligation not to divulge any confidential information you told him as a client, not as a client. How is the attorney-client privilege protected in the Nigerian legal system? The statutory provision for attorney-client privilege in Nigeria is primarily derived from common law principles and is reinforced by the rules of professional conduct for lawyers in the country. Also, the Evidence Act of Nigeria also recognizes and protects attorney-client privilege in certain circumstances. In our rules of professional conduct, the privilege is protected with the provision that all oral or written communications made by a client to his lawyer in the normal course of professional employment are privileged, and that a lawyer shall not reveal a confidence or secret of his client. In the Evidence Act, we have the provision that no legal practitioner shall at any time be permitted, unless with his client's express consent, to disclose any communication made to him in the course and for the purpose of his employment as such legal practitioner by or on behalf of his client, or to state the content or conditions of any document with which he has become acquainted in the course and for the purpose of his professional employment, or to disclose any advice given by him to his client in the course and for the purpose of such employment. Quite broad, but simply put, the law supports the client to tell the lawyer, keep your lips sealed on areas that are sensitive to the client. How is the attorney-client privilege practiced? In practice, attorney-client privilege allows clients to freely and openly communicate with their lawyers without fear of their discussions being disclosed to third parties and being used against them by the lawyers or third parties. This privilege extends to both oral and written communications between clients and their lawyers, as well as any document or materials shared in the course of legal representation. In practice, the client is made to know and understand that he can trust his lawyer and that the success or otherwise of his case depends on it. The lawyer is made to appreciate the fact that the information within his knowledge is not meant for him to do as he pleases. Examples of attorney-client privilege. Number one, a client confessing to their lawyer about committing a crime. Please note here that this does not translate to covering up a crime or fraud. If a client seeks advice from a lawyer to assist with the furtherance of a crime or fraud, or asks the lawyer to conceal the crime or fraud, then the communication is not privileged. If, on the other hand, the client has completed a crime or fraud and then seeks the advice of a legal counsel for defense or mitigation or settlement, such communications are privileged unless the intent of the client is to cover up the crime or fraud. In situations of this nature, the system allows the attorney to provide the best service possible for their client without violating the law. Number two, a client providing sensitive personal information to their lawyer in the context of a legal matter. For example, the client confesses to keeping a mistress or even bedwetting. Number three, a client seeking legal advice on a business deal or contract and may have disclosed some trade secrets, competitor information, studies, and findings. What remedy do you have if attorney-client privilege is breached? The remedy for breaching attorney-client privilege can vary depending on the circumstances of the breach. In some cases, a client may seek legal recourse through the court by filing a lawsuit against the party responsible for the unauthorized disclosure. Additionally, lawyers who breach attorney-client privilege may face disciplinary action from their organized professional bodies, which may include suspension or disbarment from practicing law. Overall, their attorney-client privilege is a crucial aspect of the legal profession that serves to protect the confidentiality and trust between lawyers and their client. The client may not want to confide in his lawyer in certain situations due to lack of trust, fear of confidentiality breach, lack of competence or experience of the attorney, or a perceived conflict of interest. But with attorney-client privilege firmly protected in our laws, clients are protected and can discuss freely. Please note that there has to be an attorney-client relationship before claiming attorney-client privilege. So retain a lawyer properly by perfecting your brief the way and manner he wants you to. Create that attorney-client relationship before you start spilling or activating that trust embedded in the attorney-client privilege. Hope this made sense and you would want to hear more. Then don't leave without subscribing. Then like this video. Did you learn anything from this video? Please comment. Would you want some other person to learn too? Please share. And I guess you do not want to miss the next upload. Then please turn on the notification bell. Until then, remain blessed.